On my kicker tonight, I throw my weight and height fully behind the Supreme Court Presidential Petition Amendment Rules 2022, which rules have stirred up controversy with sections of the legal fraternity screaming freedom of expression and others terming the rules gag orders. The so-called gag orders are specifically contained in the amendment of Rule number 18, which introduces a clause that reads, and I quote, "Upon commencement of hearing of the petition in the court, litigants, advocates, and their advocates' agents shall refrain from expressing their opinion on the merit, demerit, or predict the outcome of the petition in any manner that would prejudice or impede court proceedings until the judgment is delivered." Now, this amendment has been greeted with outrage by a section of lawyers, with one of them filing a petition challenging the amended rules, describing them as unconstitutional, vague, unreasonable, irrational, and unlawful. A petition filed by lawyer Mwanza Mbati also cited lack of public participation in the formulation of the rules and wants them quashed for violating fundamental constitutional rights and freedoms. Now, though I disagree with that bit about predicting the outcome of a court decision, I support the so-called gag order of the Supreme Court. And I support the so-called gag order for two reasons. My first reason is the sub judice rule, which can simply be termed as the media equivalent of the so-called order slapped on mainly lawyers by the Supreme Court. The media, even though being the bastion of opinion and comment, is regulated heavily by the sub judice rule, which is defined in the Black Laws Dictionary as a matter before the court or judge for determination. The purpose of sub judice rule is to stop parties from commenting on matters that are live in court. I see the amendment of the election petition rules in this same context of the sub judice rule, that rule that allows the court to go about determination of a matter in an orderly and civil atmosphere. To my second reason now, the mindless embrace of the social media as a parallel law court by a small section of clickbaiting, hashtag chasing, and celebrity wannabe lawyers. Now, this breed of lawyers have turned the social media into a platform of running commentaries on select live court matters with a dominant theme of disparaging, especially names of the judges handling those matters. The horrifying timelines, that is, their horrifying timelines, are still available for review, especially on cases like the 2017 presidential election petition and the 2022 Supreme Court decision on the BBI process. This breed of socialite-leaning lawyers have taken full advantage of the ungoverned space that is the social media, a vast open field of anything goes, a world without rules and gagging orders. When the Supreme Court delivered its judgment on BBI, I was not surprised that the court also took notice of the social media activities of some of those lawyers. And if for consistency, I agreed then and still do with Chief Justice Martha Koome that some of those lawyers had acted unprofessionally and indeed intended to, through the social media, influence, intimidate, or scandalize the court. Now, the Chief Justice and the Law Society of Kenya President met today to discuss the controversial Supreme Court rules, but I would urge them to expand the conversation to the crisis that is the emerging culture of contempt for rules, traditions, and customs. Physical fights complete with injuries have been witnessed at the Law Society of Kenya offices, and this too points to that direction of a culture of anything goes. That conversation should be brutally frank, especially on the role of rules in the preservation of institutions and processes. Now, as a journalist, I know a few things about freedom of expression. Some lawyers have argued that the amendment of Rule number 18 amounts to violation of freedom of expression. Well, I think it is a suggestion to that effect that is in itself an abuse of freedom of expression. Some lawyers in the social media have roundly dismissed the Supreme Court rules, but I am eagerly awaiting to hear from our true majority of courtroom lions, many of who do not post daily running commentaries in the social media. That is my kicker.